Hey everyone, thanks for joining me on such late notice. I couldn't decide if I wanted to do a live or not. And then I started writing up a post and then decided it was going to be more information than I wanted to write up. So, I'll do a live. And Julie, yes, make sure you change your chat from top chat to live chat. And I actually already did that before I started. For once, I remembered. Morning, Jane. And I didn't have time to set up OBS with everything. So back to just normal old Hangouts for today. No, there was no decision today. And that's what I'm going to talk about a little bit. So thanks for everyone for tuning in. As usual, just going to give it a couple seconds so that more people can come in. I actually started on time. So while I am waiting, I want to say thank you again to everyone for helping me to get to 1,000 subscribers. That's amazing. And because of that, I will be able to live stream from the rally. I have not had a chance to try it out yet, which I should probably do before the rally, but I just haven't done it yet. Also, for those of you who are attending the rally, the weather report is not the greatest. I'm okay with the 62 degrees because it's better that than 90 degrees and humid. But it also is, the weather report is calling for rain. So if you are coming, please bring an umbrella. Just to be safe. If we all bring umbrellas, it won't rain. If none of us do, it's going to rain for sure. But I'm really looking forward to seeing so many of you at the rally. And we can weather a little rain. I think we'll be fine. We're not going to melt. And it will be a little cool. So bring sweatshirts. Last year, I had a sweatshirt on almost all the time, and it was a little bit warmer than it's planning to be this year. So plan accordingly. Typical Wisconsin weather. Hi, Carla. Rain in the evening, you believe? Yeah. Well, anything can happen. So hopefully not during the day when we're outside, but you never know. Still plan ahead just in case. Okay, so I'm going to get started. Now, just like everybody else, I was hoping there would be a decision today. And the reason why we thought it was today was because of the fact that the Supreme Court rules say that any motion in front of a circuit court judge, they have 90 days to respond. We've talked about this before. And they also have the option, the judge themselves has the option to certify another 90 days if they need it. They don't have to request it, they can just take it, but they have to notify the chief judge of their intention to do so. Okay, so that's why today would have been the deadline for that. There are a couple reasons why that may not have happened, and I actually have another one that I was just thinking about today. So that's something that people haven't heard, and it's not exactly great, but I'll get to it. So since she didn't rule today, that means that, well, like I said, it could be a few things. Number one would be that she may have taken additional time. Okay, she may say, I need more than 90 days. Now, if they do ask for, or not ask, I just said they don't have to ask, but if they do take an additional 90 days, that doesn't mean they have to use the entire 90 days. Okay, they can use 5 if they have to. It's just saying that they need more time. That is something we would not be aware of that if that happened. That would be something that the circuit court judge would make sure the chief judge knows about, but we're not given that information. She's going to rule when she's going to rule, as far as we're concerned. That's all that matters. One of the other reasons, hi, Kelly. Kelly, are you going to be there this weekend? One of the other reasons that it could take longer is because, again, Supreme Court rules say 90 days from the last submission. And when you're filing a petition or a supplemental petition, like this case, there is no requirement that the judge hear or consider a response from the state or a reply from the defendant. But if she does, see, we don't know if the judge would be considering those things because the state filed a response before she ever had a chance to request one. So we don't know if she would have requested one if they hadn't jumped the gun. And that's why we don't really know if she's going to consider those things or not. Now, I have been saying, hi, Sharon. I have been saying that the last few days, actually, we just did a live the other night where we were talking about it. And I said that I don't think she's going to consider the response and the reply. I really don't. And there are a couple of reasons for that. And this is what I started writing in my post. And I was like, oh, good Lord. Like, I'll just talk it out. I don't want to write all that. The first thing is that she has ruled previously. Okay, her standard ruling has pretty much been that Steve is procedurally barred from presenting anything, essentially. If she believes, in fact, that Steve is procedurally barred, there would be no reason for her to consider the other two documents because the procedural bar would be something that would be apparent just on the filing alone. It's the same reason why she said that on the original petition, she didn't consider about 70% of it because he was procedurally barred. So essentially she saw, oh, these are IAC claims, these are this claims, whatever, Brady claims, and he's procedurally barred. So I don't need to consider it any further. Well, it would be the same situation here. So that's one reason why I didn't think she'd be considering them. Because as far as I'm concerned, the only reason, and I don't think it's a good one, to be clear, but the only reason I could see her coming up with to deny this claim is procedural bar. It's the only thing. There's just, she can't rule on the merits of this motion without a hearing. There are too many questions that need to be asked. There are too many answers that we don't know. We don't know why they did this. We still don't know all the details of what the family was told. What did the funeral home do with the bones? Why did they do this? There are so many unanswered questions. So there's no way that she can rule on the merits of the claim without a hearing. So I can't see any other reason. If she comes up with one, I'll be surprised. I'd be curious to see what it is. But I, as far as I'm concerned, that is the only reason why she could deny this motion. And again, I'm not saying it's a good one. And people have said, well, how could Steve have presented something in his pro se petition that he didn't even know about? That has really never mattered in a court of law. It really hasn't. It has never mattered. They don't use logic here. Okay, there's really no place for logic or common sense in the court system. Because again, I talked about this before, but Kathleen is also using the argument that he was a pro se litigant. He didn't even have access to his entire file, let alone access to investigators and scientists to do what was necessary to file a complete petition. And to any logical, normal thinking person, that makes perfect sense. Like, why is he being punished? Because he doesn't have the money, he doesn't have the resources to do these things. You shouldn't punish somebody that is basically trying to act on a civil right of theirs to appeal this conviction. But then you actually are really giving them no hope, no shot whatsoever, no legitimate shot because if they're advocating for themselves, they are not going to do as good as a job or as thorough of a job as an attorney would or an investigator. So so to us, it's like, that makes perfect sense. Like, you should not be punished for trying to advocate for yourself, and you should not be basically just out of luck because you tried to help yourself when you had no idea that this documentary was going to come out and that one of the best appellate attorneys in the world was going to take on your case. Steve is not a fortune teller. How was he supposed to know that? So as far as he was concerned, they'd been documenting this information for a long time, but as far as he was concerned, this documentary was never coming out. Or even if it did, it was going to be playing. I think Dean Strang has said this before. It was going to play at some little coffee house somewhere that 12 people were going to see it. He had no way to know what this was going to turn into. Even if they told him it was, when they told him it was going to air on Netflix, he probably still had no idea what this was going to turn into, or that he was going to get competent representation. But after all that, they don't care. The courts don't care. There really isn't any precedence, as far as I know, for saying hey, you were pro se, it's not fair, so therefore, we're going to give you another shot. Nope. Because again, they're going to stack the deck against you as much as possible when it comes to post-conviction relief. I know, it's so frustrating. So the fact that Steve wasn't aware of these evidence ledgers, he wasn't aware of the last page of the CASO report, that's where they would say probably that, well, if he would have exercised due diligence, he would have known about it. Meaning, before Steve filed his petition, before Kathleen filed hers, they could have filed a motion for post-conviction discovery and gotten any of the latest stuff on the case. But again, nobody had done anything with the case. It wasn't being investigated anymore. So there was absolutely no reason for them to think they would have to do that. Again, it's like they're expecting to be mind readers. They want you to be able to, well, you should just know that there's more information in an investigative report on your case that's been closed for 10 years. Okay, like it's stupid. Okay, so, but anyway, that's the argument they will probably make for procedural bar. And it's going to have to go to the Court of Appeals to make that decision, because clearly this judge does not care, and she is going to stick by that. She loves her procedural bar. It essentially is a way for her just to not have to deal with all these claims. And hopefully the Court of Appeals will rectify that. Now, of course, there's the option, still the option that she could grant an evidentiary hearing. And I laugh as I say it, because I think it's like that. There's that little chance of that happening. Again, they don't usually wait. Judges don't wait this long to grant a hearing. They want it on their docket. They want to get it done with, because it would take maybe a couple months at least to schedule a hearing. You have to wait until there's an opening on the judge's docket. You have to make sure both attorneys, both sides, that it fits into their schedules. So it's not like you can just say, okay, come in tomorrow for a hearing. Subpoenas need to go out, and it's like a mini trial. So you need time to prepare. So, I mean, 2 or 3 months would probably not be out of line for scheduling a hearing. In which case, a judge, if they know they're going to grant a hearing, or they think that the motion has merit, they're not going to say, well, I'm going to wait 3 months before I put this on my docket. They're just not going to, because, well, most judges wouldn't. I don't know what this judge is going to do anymore. So I'm just saying that right now. Like, I just do not know what this judge is doing anymore. Okay, so one thing that I remembered today was that when she ruled last time on the CD issue, she didn't consider the other response and the reply, the thing we're talking about right now. Is she going to consider those? And I went back because I couldn't quite remember why she didn't consider them. And I thought at first it was because of procedural bar. And then I read it again, and this kind of made me think of a couple things. Now let me just read it here. It's in another window somewhere. I'll find it. Okay, she said, and again, this was on the CD issue. So this was the decision and order she filed in September 2018. Nowhere in the very specific orders of the Court of Appeals did the court allow for a reply brief by the state or response by the defendant. Funny side note there, it's actually the other way around. It's a response by the state and a reply by the defendant, but what a shock. This judge doesn't know which is which. Anyway, because the Court of Appeals was so detailed in its instructions, the court did not consider the subsequent briefs submitted by the parties after the defendant's court-ordered filing. This court followed the order of the Court of Appeals and only considered the initial brief of the defendant. So that means that her reasoning was that in the Court of Appeals order, they said that the appellant should file a supplemental brief. At that time, I think it was 30 days they gave her. This time, they only gave her 14 days. And she's saying, since that they didn't say the appellant should, file their brief in 30 days, and then the state can reply or respond, and then she can reply. They did not specify that. So she's saying, so that's not why I'm considering. So that's why I'm not considering them. Well, hi all. Okay. Hi Jen. LCM. Keep that in mind. I will get to it, because you know how easily I get so off track. Or if you have watched me, you know how easily I get off track. The order from the Court of Appeals on this remand was exactly the same, except for they changed it to 14 days. But they made no allowance for a reply or a response from the state or a reply from KZ. So the judge is going to use that as an excuse to not consider them in her previous ruling. She has to stick to that in this ruling. Otherwise, she'd be contradicting herself. You can't say that the judge, the Court of Appeals didn't allow it once and now they're going to allow it. So that's another reason why she's not going to be considering those, at least according to her own rules, because that remand order was exactly the same, except for the days, and most importantly, except for the time to make a decision. And this is where I'm like, oh, okay, I probably should have thought about this before. Again, in the remand for the CD, the court specifically gave her 60 days to rule. They gave her no date at this time. That's why from the very beginning, I was going by what Supreme Court rules say for the circuit court. 90 days plus 90 if necessary. And it made me wonder, and this seems to make no sense, but it's possible. Since the Court of Appeals didn't specify a date, and since she's saying that their order kind of essentially eliminates what is standard procedure by filing these additional briefs, does that also mean that there is no time limit for the decision? She can make the decision whenever she feels like it. Disheartening, yes. Possible, also yes. It seems like a very strange thing to do, because the whole reason you have these time limits is to keep cases moving along in the system. You put judges on these deadlines so that they keep moving. It's the same reason why lawyers have deadlines. You want to keep things moving along. Hi, Chris. And so to say there's no deadline or there's no limit, at least apparently there's none that we know of, it really makes very little sense. And that's why I would think that the fallback would be whatever the Supreme Court has ruled. But it's possible it's not. And she could just rule whenever she's damn good and ready, which is sad and unfortunate. And again, this is me just kind of throwing ideas out there, because as I said, the only two reasons otherwise would be if she needed more time. She should not need more time to decide a supplemental motion. That's ridiculous. The original petition had something like 100 claims in it, and she only took a little over 90 days. This is one claim. It cannot possibly take you 90 days to decide that, period. And the other issue was that maybe she's considering those other documents. And I just went through why I don't think she's going to. So then that kind of left me with this thing. I was like, well, then what is she doing? Like, neither one of those things seems like a very viable option. So what is she doing? And that's when I was looking at the previous order and I was seeing how she was saying, that they said I didn't, you couldn't file these, so I'm not going to. That makes me wonder if there really is no deadline other than when she feels like ruling. And that's a possibility. And it's honestly something I didn't think about because, I was going by what the standard rules are, by the court. And I should have known right away, because very little is ever standard with this case. Everything, it seems procedure flies out the window on this case all the time. So this should have occurred to me sooner, honestly. But it was just when I couldn't see any other reason why those other two instances would apply that I kind of looked at them like, oh, yuck. Maybe she can just rule whenever she wants to because of that specific, following the Court of Appeals orders. I don't like to speculate, but the length of time it's taking leads to me to believe there's something going on that has not been made public. That would not actually involve the judge at all. If there's anything going on between KZ and the state, the attorneys, if there's anything going on between them two, that's not something the judge would really know about. And it wouldn't change anything as far as, she would have to rule one way or the other. It can't just disappear. So I don't really think there's anything going on. Of course Kathleen always has stuff going on. But I don't necessarily think that would be a reason why the judge wouldn't have ruled, because she has to rule either way. And again, it doesn't seem like it makes any sense that there would be no time limit. But again, hopefully, do you guys understand what I'm saying? What the reasoning is for that? Am I making sense is what I'm saying? Not that you like it or agree with it, but just does it make sense? Do you understand the point I'm making? Yeah, Julie, that's exactly what I'm wondering. Because just because of how she worded it in the previous ruling, that she's going to follow their very specific instructions of the Court of Appeals, and they gave her a time limit before and they didn't give her one now, which honestly may have been an oversight by the court, because I don't know why they would have given her a time limit. They gave Kathleen 14 days, which would suggest that they wanted this matter resolved quickly. So why wouldn't they give the judge a timeline? And again, it could have just been an oversight. How long do you think KZ will wait? She's going to wait as long as she has to wait. There's nothing she can do about it. She can't demand a judge give a response. And she can't formally make a request, hey, when are you going to respond? I mean, yeah. So, I mean, that she is at the mercy of the judge, just like, Steve is, and just like we are. Hi, Dawn. Okay, so I have to go back because I don't know if I can see it now. There was a question. What was the question? What is the logic in allowing the same judge review this appeal? Wouldn't ethical have to be a different judge? No, because it is the same appeal. This is the same petition. It's actually not even in the appeals court. Technically, it's there waiting to be heard, but it keeps getting sent back to the circuit court. So this is still the same petition as the petition she filed in June of 2017. It's all the same petition. So you can't have multiple judges ruling on the same petition. It's just that it has been presented kind of piecemeal, which is not the usual way that it works. But since the investigation is fluid, Kathleen has discovered new information as she has gone along. And so she's had to do it this way, but it's still the same appeal. So you can't have one judge rule on the petition and then another judge rule on the petition. The same one has to rule on this petition. You have one judge, one petition. The only exception to that would be if the judge fell ill, had to step down, something like that. But that would only be and that's a very rare circumstance. And then you'd probably have to start all over, resubmitting the entire petition from the beginning. Marty says it's hard to stay positive with denial after denial after denial. Yeah, well, imagine how they feel. I've always said that the prisoners actually take it better, and I'm saying this about prisoners in general, just not Steve and Brendan, but them too. They take it better than we do sometimes, because this is the norm. Okay, a prisoner going into court and filing a motion to help possibly get his conviction overturned, the norm is to be denied. It's when they get, when they win, then it's a shock. Like they don't expect to they never expect to win. It's statistically, they don't have much of a chance. So, and most prisoners have been through this entire process repeatedly. Most prisoners have filed a post-conviction or an original, post-conviction proceeding immediately after trial. They filed a direct appeal. They filed a 97406 petition. Some also go the habeas route. So this is nothing new. Like, this is something that all prisoners, pretty much any long-term prisoners, go through. And yeah, they're used to just losing all the time. So that's why sometimes it's like so frustrating for us, but it's obviously extremely frustrating for them, but they are unfortunately very used to it. And Steve went through this all in his first trial. He was denied all over the place. It was almost even more ridiculous in that trial, because they did have the fingernail scrapings from Penny that, they could test. And even though they didn't match him, they still found a way to deny him. They still found, it's kind of like with the Central Park 5 thing. When they found out that somebody else committed the crime, instead of admitting they made a mistake, they were like, well, he was just a sixth member of this group. Well, they did the same thing with Steve with the fingernail scrapings. They're saying, well, just because it's not his DNA under her fingernails doesn't mean he didn't commit the crime. And so it's the same excuse. Let's look for how many different ways we can deny this and try to justify it. Okay, let's see. Can the upper court demand a decision? Yes, they can. Yes, they can, if they want to. Will they? It's unless it's taking an extraordinarily long amount of time. But after 90 days, no, they wouldn't, I don't think. No, she can't file a motion for a response. It's not, like I said, you can't submit any type of formal thing. It's not standard to contact the court. You definitely wouldn't contact that judge for sure. That's absolutely improper. Is there a way to, I don't know. I don't know what would be allowed as far as ex parte communication and what wouldn't be. Has a judge denied Stephen Avery previously? Not this, this particular judge has denied this petition, but Steve's been denied all the way up and down since 1985. The only time he ever won was when he was his exoneration. That's it. Otherwise, Steve has been denied every step of the way. Brendan is denied every step of the way. I mean, that's pretty much the norm. It's sad to say. And most of the time, the prisoners are where they belong. But in the case of wrongful conviction, it really, 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 really sucks. I am not calling her names. Eric Jose wants me to call her that. I'm not. I don't do that. Everybody knows that. I do not use nicknames for any of the people involved. Don't ask me why. I just don't do it. Not that they deserve any respect or anything like that. It has nothing to do with that. It's just I feel silly. I don't like it. It's just not me. You guys can have fun with all the name calling. He is a troublemaker. Libby, help. Very confusing. Not sure what is happening at this point. Well, nothing has changed from yesterday. Steve's still waiting on a decision. He's waiting on a decision for her, the judge, to decide whether there should be a hearing to further investigate the facts of this disposal of evidence issue. There isn't the problem, no consequence for the state. No. And again, if anybody watched When They See Us, you see how far you can take it and there'd be no consequences. In fact, there's a lot of things that just turned my stomach watching that. But at the end, when the boys are convicted, and then you show the crowds cheering the officers and the DA for convicting those boys, it's just, it's one of those smaller things that just really enrage me, seeing them be, applauded. It's just like Wiegert and Fassbender getting Investigator of the Year awards for coercing a 16-year-old kid into confessing to rape and murder. Ken Kratz, getting an award for Prosecutor of the Year for railroading two people. It's just disgusting and it's sickening. There's not enough adjectives to describe what it is. If TZ were to have a new finding that she needs to amend, can she do so while waiting on this decision, or does the decision have to be made first? She could amend if she has new information pertaining to this specific claim. She can't file another new claim or anything new. But if there was additional information or additional, if she wanted to cite an additional authority, meaning more case law, if there was new case law, she could supplement her supplement with that. But nothing like that has happened as far as I know. Well, let's see. If Judge S does indeed drag this out indefinitely, is there any way the appellate court can legally endorse a deadline? Yes, I think I just answered that before. Sorry if you missed it. Yeah, I mean, the Court of Appeals is driving, the car on this one. She's just kind of following along. So if they decide that she's dragging her feet, they can order they can give her a deadline. But again, by court standards, 90 days is not a long time. It's really not. And the Court of Appeals is going to take a year probably to make their decision. So, but they won't let it drag out that long. But they can. I'm sure that the judge is well aware of what her limitations are and that at what point she's really going to have to start, going to have to respond. Because again, 90 days is traditionally the deadline. So I don't see her going too far past that. I do not see her taking another 90 days for sure. I mean, that's ridiculous. To me, that's an abuse of power. It is, to take that long on a supplemental motion. This is not the most complicated thing in the world. It really isn't. It's a supplement to a petition. It's not even a full petition. Does she have max of 180 days? Well, traditionally by Supreme Court rules, she would have a max of 180 days. But if it's, if I'm right and it's possible that she doesn't have a deadline, I mean, technically she could take more, but I don't see that happening. Love you, Linda. Can't wait to see you. I don't see that happening. it doesn't make a whole lot of sense to me. But not much does. I admit that. I just wanted to come on to this when I was reading that previous decision. And again, I was looking for something completely different. I was looking for her reasoning, thinking it was procedural bar, why she wasn't considering the other issues. And then I read that again. I was like, oh, I forgot about that. She was actually saying it was because of the Court of Appeals order that she didn't consider the other issues. So then that kind of just led one thing and to another of me thinking about things, and why I decided to do a video and not just write one of my infamously long Facebook posts. So I think that's all I really wanted to say on that. I mean, we've covered most of it before. I just wanted to add that little bit because I know that people were waiting for the deadline today. And even though it prepared them that it could take longer, I wanted to add that there could be an additional reason why it's taking longer, because I said those other two reasons just aren't sitting well with me. I just don't buy it. I don't buy that she's considering the other documents. Her own ruling reinforced that. And I don't buy that it takes 90 days it takes more than that to rule. If you're gonna grant something, for sure, it wouldn't take that long. I don't think she needs additional time for that. So she's just taking her sweet ass time. It's the best way I can put it. My wardrobe looks like my door. Yeah. Yeah, a line will be drawn at some point. I said she can't drag it out indefinitely. She can't. I mean, there's no way that she can do that. Can she drag it out a little bit? Yeah, apparently so. It would take a little bit before the court was like, okay, what are you doing? You need to rule on this. I am just surprised that they would only give Kathleen 14 days, and the suggestion being that they really wanted to move this along and then not give her a deadline. They gave her 60 days. They gave the judge 60 days when she filed the other supplement. This time they only gave Kathleen 14 days to put it together, and they're giving her this longer amount of time. It doesn't make a lot of sense. And again, it may have been an oversight by the court. And if they do feel like it's taking too long, maybe they will put an order in, because their intention may have been for it to move along faster. Maybe they meant to put the 60 days in and they forgot. I don't know. Who knows? Yeah, they're saying that Stephen Casey took too long. Yeah. And like I said, we don't like the waiting, but this is not unusual for a court case. Okay, like we think 90 days sounds like an eternity, but there's a reason they will give them up to 180 days to rule. I mean, it happens. So we don't like it. And like I said, you look at the rulings in some of the higher courts and they take a lot longer than this. So it's by, court standards, this is not a lot of time. By our standards, it is. And certainly by Steve's standards, it is. But by court standards, 90 days is not a long time. I mean, Kathleen asked for extensions that lasted 90 days when she was filing things. So, I mean, hate to say it, but, again, in legal time, that is not a long time. It's just that for us, there's nothing else going on. We want something to happen. It seems like it's been forever. But when you take a look at, like I said, at the legal system as a whole, 90 days is just not a long time. Any thoughts on the Fallon sabbatical? I talked about that in the group a little bit. I really don't think it's anything necessarily to think means anything. People take sabbaticals for a lot of reasons. I had said, and it was Tina that actually told me this because she used to work for the government, and she'd said that sabbaticals are usually taken for educational purposes or religious purposes. If it's a health issue, it usually falls under FMLA. But I was thinking about it later after I was talking about this, and he certainly wouldn't call it FMLA or medical leave if he was has an auto response to an email. He could have just called it a sabbatical because that's what he called it. It might not be an actual sabbatical. It could be a health issue, and he's just not saying that's what it is. So we really have no idea why he's taking the sabbatical. He is still an attorney of record of the circuit court case. He has not been removed from the case. That's the most important thing. Like, don't think that he's removed from the case. He's not. It's a little strange to take a sabbatical when you're in the middle of waiting for a decision, but I also think it's a foregone conclusion she's going to deny. Or the plan is that I'm taking the sabbatical, and if granted, well, then I'll be back. He can't get away from dealing with it unless he withdraws from the case. He'd still have to be called as a witness, and then he'd be under subpoena, so he can't avoid that either. But there's a lot of reasons he could take a sabbatical. It could have something to do with Steve. We would love to think that it's because he's so mentally exhausted and guilty that he can't handle it anymore. But there's honestly actually no evidence to prove that whatsoever. He could be taking it for, it could be because of Steve's case. Might have absolutely nothing to do with it at all. The only thing that I thought was a little strange was that he didn't specify a time frame. Usually he just said, I'm going to be out of the office for some time. Now, again, let's say it's a health issue. You might not be able to put a clock on that, so it's not one of the strangest things I've ever seen, that's for sure. It's just, a little unusual, but I just try not to read anything into it because we don't have any information. It would all be speculation. Okay, T, what you got? Was there any merit to the request form for additional photos of the RAV4? You were in that chat. You already know we talked about this. As far as the FOIA request goes, okay, I don't know why Steve did it. I just can say, knowing Steve, that I would guess that somebody brought something to his attention, and that he wanted to satisfy his own curiosity with these pictures. That's it. If it was anything that was a potential like smoking gun, going to break the case open, whatever, that would go through Kathleen. That wouldn't go through Steve. That would be something that Kathleen would be doing, and she'd tell Steve, stay out of it. Like, I'm handling this. This is probably, I would guess, something, and again, this is just a guess. I've not talked to Steve about it. I would just think that he just is really curious about something, and somebody brought something up to him, maybe got in his ear about something, and it's bugging him, maybe. And so he just wants to see these pictures for himself. Don't read too much into it. It's just Steve wants to see these pictures. Again, I think if it was anything that was potentially like earth-shattering, it would go through Kathleen. I don't think that it would go through Steve. And I know I saw people somewhere suggesting that Steve can get it quicker through FOIA requests than Kathleen can. First off, Kathleen can make a FOIA request just like anybody else. And second of all, she actually probably could get it faster going through back channels than a FOIA request as far as pictures go. Also, I know that Kathleen has a lot of these pictures, so she might even already have them. And this is just something Steve is doing on his own. I think that Earl actually even said something like, this is something Steve's doing on his own in one of the comments in the group. So again, don't read too much into it. Steve's just got something in his head. Is Rally going to stream live? We're going to try. I mean, that was the point of getting me to 1,000 subscribers, and trying to get Paul there. And but Allie, Eric, Jose, and I can all stream. Last year, my phone died so fast, so I have to remember to bring a portable charger, and hopefully I can stream more. But I don't know. I even got a new battery in it, even though iPhones are really hard to get a new battery in. But I got a new battery, hoping that it won't be as big of a problem. But Manitowoc does not like my phone. It just dies so quick up there. So I'm hoping that I can stream more. I'll do my best. And Julie just answered your question too in the chat. So perfect. Okay, so is there anything else about this? Because I did want to chat a little bit about the clemency issue, because I know that's been going around too. So I just wanted to talk a little bit about that. And again, if you watched the live video the other night with, was it Eric? Yeah, it was Eric Jose's video. When we have all of us on there, I can never remember who actually started it. It was one of Eric Jose's that he had the wrecking crew on. I can do it. Yes, I can. You can do it. I'm going to make sure I put Carla on there when she's doing something really embarrassing, because that brat always likes to take a picture of me when I'm not paying attention, and I always look terrible. She's awful. She's sneaky, and she's mean, and she's awful. When it appears that Judge S might be corrupt and in cahoots with the state, who investigates this? Again, that would be the Judicial Committee. That would, but again, there's actually no evidence of actual corruption. I am annoyed with this judge, but I would not step so far as to say corruption at all, because there's no evidence of that. And again, I will not accuse people. And I was actually thinking about this the other night, because I know a lot of people handle things differently than I do. And when I say things like, I don't do this, I know I don't do that, I mean me. I'm not saying nobody else should, and I'm not judging people for it, but there are some things I like people to be mindful of, especially when it comes to hurling accusations at people. One of the reasons that I started talking more about the law is because I really got upset, even with myself, about the theorizing and making accusations. Very early in the beginning, I was convinced that Josh Rodan did it. I could explain half the stuff away. I was thinking that he did it, and that's the only time I really put a theory out there. And I even didn't say much about it, but I still suggested that I thought that he could be responsible. And I had some other information kind of behind the scenes that made me think that too. So I wasn't just making some crazy accusations. And I know at one time, I think Kathleen thought he was a good suspect, and so did Steve. But when the petition came out and Kathleen said he was cleared, first of all, I was like, oh man, I thought there was all that stuff I found out about, I thought was going to be in there, and it wasn't. But I felt really bad. I felt really bad once Kathleen said that he's cleared, he had nothing to do with it, and he was actually being helpful with her to her. I felt really bad that I never flat out accused him, but I just suggested, like, I think he may be the killer. And I felt horrible about it. I really did. And I see a lot of people doing that. And I do tell people, like, to be careful to say, if it's a theory, if you say I believe, or I think, at least. But even that still bothers me a little bit. But I really hate it when hear people say Ryan Hilgis is the killer. I don't like that. We are here because two men were falsely accused, falsely arrested, and falsely incarcerated. I just don't believe anybody should be calling somebody a killer or accusing them of any other crimes without all the facts, and especially without being in a court of law. And it sometimes baffles me because we're here because of two men who were treated that way. And yet I see people doing it every day. And I just don't like it. But again, like, your mileage may vary, do as you like. But I do want people to keep that in mind. It's fun to theorize, it's fun to throw ideas around, but remember that, you want to be careful about calling somebody a murderer. I know Travis is going to agree with me that for sure. The lawyer, of course, is going to agree with me. But again, I'm not saying that I'm like, like you have to do what I do or whatever. I'm just saying that's kind of my philosophy on it. And that's one of the reasons why I stopped with a lot of the theorizing. Yes, Ryan Hilgis is quite a suspicious fellow. That is an okay thing to say. You can say he's suspicious, or he did things that seem kind of, questionable, or, like saying someone's a suspect or whatever, that's fine. But calling somebody a killer, not okay. I brought this up like over a year ago. I remember bringing that up, and I guess I haven't talked about it in a while, but I was thinking about it the other day that, yeah, there's a lot of people that are suspicious. And there's a lot of people from different areas of this that are suspicious, and yet they all didn't do it. So, so that's why I said, I just say, try to be mindful of that, and think about what happened to Brendan and Steve when people, and again, if you just watched, the Central Park 5, case, if you just watch that, I mean, think about what the people said about them and their families and everything, and all the unfair accusations that were made because people jumped to conclusions without having all of the facts. So that was a little side note for me while everybody was still talking. Okay, is there anything else about any of those topics before I move on to the clemency thing? And again, I talked about this on Eric Hosey's video a little bit, so I'm just going to mention it, though, to anybody that might have probably missed that. I need a drink, though. That sounded good. I need a drink. Kind of do. It's been a day. Okay, so I'm going to move on to clemency. Now, I didn't address this at the time, but a few weeks ago, Steve Drizin had tweeted something about the wait is almost over. And I didn't know specifically what he was referring to, but a lot of people that were close to Brendan, I know Brendan pretty well, were saying it was about clemency. Seemed a little strange to me. I am hitting the bottle. I wish I should put it in a paper bag. That would be so awesome. But some people were saying it was regards to clemency, and I didn't really understand that, because right now, Governor Evers does not have a pardon advisory board right now. He's working on it. And he said he's hoping to have it put together soon. When is soon, I don't know. Hopefully within months, not years. It would be months. It wouldn't be years, obviously. But, oh, hi, Sandy. So that's something that, isn't put in place yet. So I was like, what do you mean the wait's almost over? I wasn't sure. I still don't know if that's what it was about, to be honest, but I just know other people were saying that it was. So then it made me think again. I have talked about pardoning before. I've talked about clemency before. And I just want to go over that a little bit again. Now, the first thing that I want to say is that the terms are used interchangeably, and they shouldn't be. Clemency is the umbrella term for different types of relief. You have pardons, which is what most people talk about. You have sentence commutation, and you have reprieves. Reprieves is not going to really apply at all. A reprieve is when something is delayed for whatever reason. You see them a lot in, and obviously death penalty cases, that the person will get a last minute reprieve from the governor, the president, whatever. And that means that they're delaying the sentence being carried out. They can also be given for somebody who, say, is terminally ill in prison. They may have a life sentence, but they're not going to last much longer. So they are given like a mercy reprieve where they get to spend their final days at home with their family. That can happen too sometimes. Obviously, neither of those circumstances apply to Steve or Brendan. Oh, don't worry, Linda. You'll get to meet her. I'll drag you over there myself and introduce you. I'm getting Sandy's autograph, by the way. She doesn't know it yet, but I am. I don't have an autograph. I need an autograph. So anyway, okay. So the other two parts then of clemency are pardoning and sentence commutation. And everybody talks about pardons, but I still don't think people completely understand what a pardon is. But it's used a little bit too loosely for each circumstance. I said this the other day, like when you say clemency, you can be referring to any of those specific areas. When you say pardoning, you're not, you're referring to clemency, but you're referring to a specific component of clemency. Okay, so they're not completely interchangeable. Sandy, are you behaving? I see you typing a bunch of stuff. You better behave. Now, when it comes to Steve and Brendan, I have said before that I don't see them getting pardoned. Okay. And the reason being, well, Steve is not going to even apply for one. Steve was very clear that he is walking out of prison one way, and that is as an innocent man, period. He would not apply for a pardon, nor would he accept one if they gave it to him, because a pardon is not an exoneration. Steve is exonerated or nothing. Okay. He has been fighting too long, and he's not taking any kind of deal to get out. You prove me innocent or I'm staying here. That is his feeling on it. And he's very clear about that. And I mean, Sandy has pointed that out too. So I'm not just talking out of turn or saying something I shouldn't. Steve has made it very clear that's what his intentions are. Sandy's behaving. Well, that's not often, you don't know her like I do. I'm just kidding. She's sassy. Sassy pants. So Steve is kind of out of the equation as far as the whole clemency thing goes, by his own choice. Okay. Now, as far as Brendan goes, it's a different story. I know Brendan that has expressed interest in wanting to, or at least his lawyers have expressed interest in wanting to apply for clemency. Now, the reason why I don't think that a pardon is going to be what he could be granted. I mean, all of them are a long shot. Let's be clear about that. But for a pardon is generally reserved for somebody who has already served their time. They are still considered a convicted felon. That doesn't get erased. You are still a convicted felon. Usually it's after a waiting period. The last governor, it was 5 years. After you've been out of prison for 5 years and you've proven that you can be a productive member of society and that you followed all the rules and you haven't caused any trouble, you can be considered for a pardon. What a pardon does is it restores some of the rights you lose by being a convicted felon. And generally, the main reason why they are granted is because there is such a stigma attached to convicted felons. And it is hard for them to have any kind of livelihood, to find a job. So when you go and apply for a job, you still have to check that box that says you're a convicted felon, but you can put that you have been pardoned. that you have received executive clemency, and you can even provide the paperwork, which does go a long way. Basically, if the governor is saying, you know what, this person deserves a chance, it's going to help a lot as opposed to somebody who hasn't been pardoned. So the fact that Steve and Brendan are both still incarcerated already kind of limits the odds on pardoning, because that's not usually how it's treated. But the thing that could apply, or would apply, in my opinion, would be sentence commutation. That would be the one thing that I think that could be a possibility for Brendan, in the future. There are some logistical issues with it, but I don't want to throw that out the window and say no chance. Like I said, I don't think there's high chance of a pardon, but I think there's a realistic chance of sentence commutation. Now, there are a lot of factors that go into that. Yeah, he can grant pardons for any crime short of treason and impeachment, but traditionally, I said again, going by some of the previous applications and the way the pardons have happened previously, it has been pretty standard that it's after you've completed a sentence. If you are currently incarcerated and you want to apply for a pardon, you have to get special permission to do so. So you can do it. It has been done. It's just not usually the way that it goes. Again, usually if you're in prison, your best chance is sentence commutation. Yeah, leave it to Travis to just throw the law at me. Of course. Love you, Trav. Also, there is a lot that go. He's like that's right. He's typing it in there for you guys. He's recapping what I'm saying. That's what he's doing. Just in case you're wondering what Travis is doing, he's usually recapping the things that I say, so that if people are watching later or they want to go through, they can kind of find where in the video I talked about it. He's not just copycat. He's not just a copycat. Well, he could be. But. So anyway, Paul, you are ahead of me here. Yeah, he's summarizing for the audience. Okay, so going back to for a pardon, there's a lot of steps that have to be taken. And that includes notifying the judge, the district attorney, the victim's family, and they all get to weigh in. And obviously that's gonna yikes, that would actually happen on any type of clemency, but it would be a huge issue if he was going to be pardoned. But for sentence commutation, it's a little different, because they're not saying that you're being pardoned for these crimes. They're saying, though, that we think you have served enough time based on what you did. Okay, now, in general, rape, murder, mutilation of a corpse, 13 years would not be a long enough sentence for that. Okay, but Brendan has a couple things going for him. Number one is that even though the confession was ruled voluntary, 4 federal judges did not believe that it was a voluntary confession. Okay, that made him lose in court overall, but that still matters. You have 4 federal judges that are saying, we don't think this confession was voluntary. And even the judges that didn't agree with that gave a lot of indication, even Hamilton did, that this is more of a procedural issue under AEDPA. Not because we necessarily think he did this, but because we don't think that it's so clear that we can overturn his conviction under AEDPA. And that's something that works in his favor, because when you look at the cases, the appellate process as a whole, and then you see all the support that he's had through the different amici amici, amici. I always hate that word. I say it different every time. But that still works in Brendan's favor, even though he lost in court. When you're talking about a governor, that's something that he can still look at. Now, another reason I don't think pardoning is the best option is because you got a lot of angry people in the state that still think these guys are guilty. And a governor has to justify to his people why he would be pardoning this person. Sentence commutation is that he still served time. He's not, that's not going anywhere. He's still serving his time, but we don't think 45 years for a person who was sentenced when they were 16 years old is an appropriate sentence. So they could commute the sentence to a shorter amount of time, or even to time served. Now, to do that, they may have to change things to justify things a little bit, because again, trying to explain that you only deserve 13 years for the crimes that he's convicted of would be a tough sell. So there's some options that they could do. They could, end up giving a lesser charge, or dropping one of the charges or something like that to justify a sentence commutation. But that's a whole nother conversation. I just want to say that sentence commutation is a realistic option, and why he does have some things working in his favor, even though he lost in court. There is still a lot of legal support for him, and there are still a lot of questions about this confession. Now, I mean, the governor could read that confession himself and think it's garbage, and think, I don't think he deserves to be in prison, and can commute a sentence. I mean, the governor doesn't need to answer to anybody. That's the whole point of having executive power. Now, he's going to have a pardoning board that is going to recommend pardons and review a lot of this stuff, but he could have his own opinion. And if he thinks Brendan's innocent, he doesn't have to answer to anybody else. That's the power he has. How and when does the governor have the ability to step in? Well, now. When he has a pardoning board set up. First step, get a pardoning board together. Then you have to set up the procedure. You have to set up what's going to be required, the application process, what a prisoner needs to do. And then obviously all the paperwork needs to be submitted. And again, as I was saying before, usually you have to contact the judge, the victim, the DA. They are all allowed to weigh in on this potential clemency. You have to put ads in the paper usually to let the public know that you're requesting clemency. And the governor, there will usually be a hearing, an open hearing then, where people can come in and voice their concerns. So there's a lot of steps to it. It's not a fast process. But he is currently working on putting together a pardoning board. He has said that publicly. And again, it could be months. Who knows how long? Could be next month. I don't know. Could be 6 months. It just really depends. He's got to put the right people in that position. Now, the big question would be, well, to me, it's not a question, in my opinion. If Brendan was offered sentence commutation, you take it. You take it, period. The downside, and a big downside, would be that he would get no wrongful conviction compensation. And my answer to that is, who cares? You're free. Brendan is 29 years old. It sucks because he certainly deserves compensation for what he's been put through. But if it's a choice between money and possibly having to spend another 25 plus years in prison, I take the freedom. And I don't know what Brendan would do, but I would hope that he would think the same thing. He's a young man. He still has plenty of life left, and he can do things. So if he was ever offered that opportunity, do not let money stop you from your freedom. It's just not worth it. It sucks because, they're basically getting away with convicting you, an innocent person, and you have no recourse. You can't sue them or anything. But again, freedom is the most important thing. And yes, as Fen just said in the chat, he can continue to fight for an exoneration when he's out of prison. That doesn't mean that he has to stop declaring his innocence and fighting for his for an exoneration. He can still do that. And I'd much rather do it from outside prison than inside of it. So it doesn't mean that an exoneration will never happen. Yeah, Linda agrees. I would hope most people would agree. Anybody that says, nope, Brendan should stay in prison for risk being in the prison until he's in his 50s, just so he could possibly get money someday. It's a ridiculous thought. He can still get exonerated. And then, if he's out and he gets exonerated, he can sue still. He absolutely can. But I'd say the number one priority is to get out. Okay, Travis is saying that Evers has received over 1,000 applications for some sort of clemency since January, which I think is kind of funny considering he doesn't even have a process in place yet. There are going to be a lot of applications. And this is a rare occurrence. This is not something that is done often. And usually this is done when a governor is leaving office. It's like their last thing that they do when they leave. They're like, okay, pardon, and they pardon a bunch of people because they don't want to piss anybody off, and they don't want to affect their chances of re-election, so they don't do it while they're in office, and they do it when they're going out, and they're like, okay, now I'm going to pardon all these people, and then tells the new governor, now you deal with it. So that's all I really wanted to say on that. I didn't really have a lot to say on it. I just want to make clear what the different options are, what I do think is a realistic option for Brendan, and to get people to maybe understand the differences between pardoning and sentence commutation and what it means, and why I do think that Brendan has some stuff going for him in this area. Yeah, there is a huge backlog of pardoning applications. So it could be the current applications that are still sitting there. That's true, because Walker did not do any pardoning. And I know he's been blasted for that a lot, because it is part of his executive power to pardon. One of the reasons why governors don't pardon very often, and this was the reason why Walker didn't do it, is because it's not just because he's a jerk. Okay. I mean, a lot of people think Walker's a jerk, yes, but that's not the reason for not having a pardoning system. We have 3 branches of government. Okay. Here's a little history lesson or civics lesson for everybody. We have the executive branch, which would be the governor, president. We have the legislative branch, and the legislative branch are the people that create the laws. They write the laws. Okay, interesting. Okay. Sandy, are you leaving me? Or are you just saying see ya? I don't know. She's slow answering. Anyway, sorry. I got interrupted by a message in there. I was reading it. Okay, gosh, I'm saying. Okay, so yeah, as I was saying, you're leaving. Why are you leaving? Is there a baseball game on? It's usually why Sandy leaves. Okay, well, I will see you this weekend, dear. See you soon. Okay, as I was saying, 3 branches of government. You have the executive, the legislative, and the judicial. Okay, so the legislation, they are the ones that create the laws. Okay, the judiciary creates case law. Okay, it's not necessarily new law. They expand on existing law in our Constitution. They are not writing new law. At least they're not supposed to be. Okay, that's the difference. The reason we have 3 branches of government is because it's a division of powers. It's supposed to keep one branch from being too powerful. Okay, it's supposed to be a balance. When you're talking about pardoning or clemency, you're giving the executive branch the power to supersede the authority of your judiciary, including your Supreme Court. That is not something that a governor takes lightly. Okay, that's the whole reason we have a division of power. And giving one branch the power over another one can cause a lot of problems, which is why things like that don't happen very often. We give our governor this power in extreme circumstances. But again, it's not something that they take lightly or something that they're going to want to do very often, because you're going to piss people off. You're not going to piss people off. You're going to piss off your Supreme Court, your Court of Appeals. You're going to get an entire branch of government. So it's not a little deal. It's a pretty big deal to do that. And that's why it's a rare thing, because the whole point of having, the different branches is so that one doesn't have more power over the other. They're equal, but not when it comes to executive clemency. They are not equal. The governor has more power than the judiciary. And that's why Walker did not have any pardoning. He just happened to believe in that separation of power, and he did not feel comfortable pardoning people when the courts had more experience on these cases. They knew more facts, they knew more information, and he was putting it in the hands of the judiciary. I understand that thinking. I think it's a little short-sighted, because that's essentially saying that they're infallible. They can't make mistakes. The whole point of a governor having that power is to try to rectify mistakes of the courts. So I don't necessarily agree with it, but I do understand the thinking. So it is a sound way to think. It's just that in practice, it can be a little short-sighted. Jennifer, you finally made it, and I'm almost done. So, have I covered everything good enough for everybody? Is there any other questions? I hope, was this helpful? I always ask, was this helpful? Oh yeah, okay. Linda, I never do this because I'm terrible at it. Yes, please hit the like button. I don't know why. People tell me it's important. Hit the like button. If you haven't subscribed, subscribe. If you want to be notified whenever I go live, especially at the rally, there's a little bell there, like someplace. Hit that so you make sure you get notified. You can tell I'm a YouTube expert here as I'm just spouting things, so I have no idea what they are. But people tell me it's important to do these things. Thanks, Travis. You like anything I do, though. You're so nice to me. Is Eric Jose still here? Are you going live later too? He might have bailed. Not sure. I tried to do it early in case. That's why I kind of rushed it. So I was like, I didn't know what Eric Jose was doing tonight, and so I didn't want to. I mean, usually he goes on later anyway, but I still want to make sure I was done before he went on. I'm laughing at you, but you're doing great. I know. I'm so dumb when it comes to this stuff. I will see you Saturday, Victoria. I'm looking forward. Are you coming up Saturday or Friday? You're coming up Friday, aren't you? If Eric was still here, he's just not listening at this current time, or he's got sidetracked somewhere. That's okay. I'm almost done, so I know he's not on right now. Maybe he can. Hopefully, he saw the beginning and he can just reiterate what I already said, so I don't have to explain it again. You're coming up Friday. Okay, I think most people are coming up Friday. I still know exactly what I'm doing. Playing it by ear. Okay, see, Sharon knows more than I do. She said there is sometimes extra options on the notifications bell. It asks if you want to be notified by videos, live videos, whatever. Do what Sharon says. Hit subscribe. Yes, I'm checking in on Friday. I'll have Marilyn with me. Angie's not coming up now on Friday. She's not coming up till Saturday. So you just have us. And then I think Christine's coming up too. But so yeah, so hit the like button, please. Pretty please. Hit the subscribe button. And if you want notifications, hit that little bell and do what it says. Otherwise, I'm going to see a lot of you in this chat. I'm going to see you this weekend, and I'm really looking forward to that. Otherwise, I don't plan on making another video before then, unless something happens. I'm actually really busy this week, crazy busy, running around. So before Friday, so I'm hoping I don't have to do another one, unless it's because there's a decision. I would be okay with that. I know. I can't wait to meet you guys in person. It's so weird because I feel like I know you all so well. And you're welcome, Martha. All right, that's it. I was only a little over an hour. That's pretty good for me. Okay, that's it then. Thanks for joining me. And thanks, T. And I will talk to you all soon, hopefully this weekend from the rally. See ya.